My name is Attorney Wendy Guthro. I'm a licensed practitioner in Massachusetts and New Hampshire.
She's doing her
I'm part
presentation.
of the National Academy of Elder Law Attorneys, and I'm licensed to practice in the state and federal courts. Today's presentation is for informational purposes only. I am not giving out legal advice specific to you, and that it's important for you to know that if you have not signed an engagement agreement with me, that I am not your attorney and I'm only providing general counsel in this presentation. Let's talk about the difference between a will versus a trust. Again, a will is a document that distributes your assets after you pass away to the next owner using the probate court system, versus a trust is a legal entity, a container that can hold assets, money, real estate during your lifetime and distributes them after you pass without using the probate court system. There's a graphic depiction of what the processes are if you use a will versus if you use a trust. It's a public process. One of the documents that we need to submit at the beginning is probate, is an inventory stating, do you have a house? Do you have a vacation home? Do you have retirement assets? Or maybe you didn't name a beneficiary. Do you have a bank account that was only named by you? Did you not name a beneficiary designation on your investment accounts? So all of those assets would be individually listed on an inventory. And when we go to close probate, we are going to have the final numbers of what's been paid, how those assets might have been reduced to pay debts, and then what is the final amount that is going to be distributed to each beneficiary, whether they're named in a will or if you don't have a will, we are still going to probate and using this similar process. So, whomever the beneficiaries are and the amount of money they're going to be walking away with becomes part of the public record that anyone in the world can go into the probate court file and look at it online. And I also say there's no asset protection planning available. Medicaid, Mass Health, they use the probate process to be made whole and to get reimbursed with a state recovery if you have used any of Mass Health services to pay for a nursing home care. So that's why it's important to have assets not go through the probate court process so that we don't have to worry about a state recovery for Medicaid. On the other side of the table, we have the trust again. And you can see we have a very peaceful trustee. We're not involving a court. We're not getting a personal representative. We have the document that you drafted, that trust document that says during your lifetime, you're the trustee. I'm going to hope for a miracle. And other people, and the majority say, if death is imminent and there's no hope and I have no quality of life ahead of me, I am fine with you removing me from all life support and letting me die with dignity and naturally. So that is the advance directive that nobody wants to talk about. So as you can see, maybe on this sample, it talks about cardiac resuscitation, ventilators. The backside goes into dialysis, ventilators, food, water, things like that for really life sustaining. And it has a lot of area that you can fill in specifically. I will be kept alive on a ventilator for up to 2 days to determine whether I can live without one or not. So you can add some nuances onto this document. I suggest when you go to your PCP, if you don't have this document, ask them to go over a MOLST form with you. And it's in bright pink paper. And that is because some clients take this home, put it on their refrigerator, especially if they do not want to be resuscitated, along with their DNR order that we're going to go over next. And EMTs know to look for bright pink MOLST on your refrigerator. Again, the DNR, do not resuscitate, only issued by a medical professional. And this pertains simply to your cardiac system. It instructs healthcare professionals not to perform CPR in case of a stopped heart or stopped breathing. So, the summary of part one, the cornerstone documents, the will, revocable living trust. These are the 6 cornerstone documents: the durable power of attorney for finances, healthcare proxy, HIPAA advance directive. And I didn't put those other 2 documents here because I can't draft them for you, but it's the MOLST and the DNR if those are appropriate to your healthcare situation and decisions. So these are the basic legal documents and financial documents to ensure your healthcare and your financial decisions are carried out no matter what life throws at you coming down the pike. We're moving on to part 2 of the presentation. And this is for you to understand the difference between a will and probate, the revocable trust, and an irrevocable trust. Probate. We covered this briefly. It's the legal process that transfers a deceased person's assets and settlement of debts under court supervision. We always talk about you want to avoid probate, get a trust so you don't have to go to probate, fund your trust to avoid probate. Why do we want to avoid probate? So let's talk about that. In that graphic depiction, I went over some of the reasons why, but here it is in a little bit more detail. It's time consuming, takes a minimum of 1 year. Assets may be inaccessible to beneficiaries for the entire length of probate, especially if it's a contested probate. It's a public process, maintains confidentiality of estate value and distribution details. That's why you want to avoid it, so that you can maintain confidentiality. The costs associated with probate, there's court fees, there's legal fees, and there's other administrative fees that if by chance you don't have a will and you own real estate and we have to go to probate to determine who gets the assets next, including the house, well, we not only have to open up probate with all of the documents, we then have to get a license to sell from the court that gives the personal representative appointed the authority to sell your house. Unlike if you have a will with the authority to sell the house, or you have a trust with the authority to sell the house, we can avoid getting a license to sell. The fourth reason why you want to avoid probate is the complexity, especially on a large or complicated estate. Hands down, we see this lead to delays and beneficiary disputes. Even in 1 year, I see probates leading to beneficiary disputes. So it's much more helpful if you have things in a trust, because if you are going to do a will and you have a complicated estate, that you are maybe giving one beneficiary or child more than another, that even though it's in your will, the disgruntled beneficiary has a very easy way to contest the probate process and have their voice heard. Compared to things in a trust, a disgruntled beneficiary can still bring an action against a trust. It's just a lot more complicated. And then control. Maintain control over how your assets are distributed. If you if you don't have a will, the probate court, Commonwealth of Massachusetts, has their idea of how things are going to go. So if you can avoid the probate process, then you exercise a lot more control over how your assets will be distributed. Strategies to avoid probate. So trusts obviously are one. The second one is joint ownership of assets. I brought that up when I said if a spouse or a parent and a child or a person and a friend have an account that's jointly owned. So that might be a bank account. It could be an investment account. So any asset that has joint ownership attached to it, even a car title, that avoids probate. If you have a beneficiary designated on an asset, such as an IRA or a brokerage account or a bank account, there can be beneficiary designations on bank accounts. That will avoid probate. Lifetime gifting. A lot of people don't think about this as a way to avoid probate because if you don't have a will, but if you give away all your assets during your lifetime and you die owning nothing, well, that is a form of how to avoid probate because during your lifetime you gifted away all your assets. So you don't have to do a will. You don't have to do a trust if you want to do some of these other methodologies. But I do like a trust specifically because I mentioned earlier, if you have five children and you name one child as the joint owner on the asset, or one child as the named beneficiary on something, or you gave your bank account during your lifetime to one child, they are on no legal obligation to share those assets with any of their siblings, even if you had directed them to do that. We're moving on to trust. So that's pretty much wills and the probate process. Now we're going to go into trusts, revocable versus irrevocable. I want to refresh your mind on the three parties to a trust, and that a trust is simply a container to hold things during as well as after your lifetime. The grantor, normally you, the trustee follows the directions of the trust, and the beneficiary uses the assets in the trust. For estate planning purposes, when we do a revocable trust, you are normally in all three positions. Common uses of trusts. They avoid probate. They maintain estate privacy. They are ready for incapacity planning. They can reduce estate and gift tax liability. There is a Medicaid qualification trust, a Medicaid asset protection trust, irrevocable trust that starts a 5-year look back period. And there's also special needs planning trust for special needs or handicapped individuals. Two main types of trusts, revocable versus irrevocable. The irrevocable is in red throughout the presentation to kind of bring your attention that it is a real different animal than a revocable trust. A revocable trust avoids probate. It maintains your privacy protection. It has flexible asset management because, again, you can do whatever you want with the assets in there. It's already set up for your incapacity. So you're using the trust while you have capacity, but upon your incapacity, we already have the asset management set up for your successor trustee to come into play and start managing those assets for you. And it's smooth succession planning, just as we have the successor trustee set up upon your incapacity. We could have that same or a different trustee set up for upon your passing, as well as that you own the assets during your lifetime in this container, and we are ready after we pay the debts of your final wishes and things like that upon your passing to make a smooth transition of those assets to the named beneficiaries in your trust. So walk away with that it's changeable and that you retain control, and that anything that you put in this trust container is yours and you can do with as you wish as long as you remain the grantor of this trust. We've moved on to the irrevocable in red. You're divesting yourself of assets, right? Unalterable terms. You forfeit control. This is primarily used when you want to do some asset protection planning. It shields assets from creditors and lawsuits, normally after a little bit of time goes by. There's tax efficiency. It can reduce estate and gift tax liabilities. It can be used for Medicaid mass health qualification. So it aids in eligibility for Medicaid benefits if you fund this trust 5 years prior to you needing a nursing home. They're used for charitable giving advantages, and that you can get financial security for special needs individuals because we can create these trusts where if you have 5 children and one of them is a special needs person, then we can create a special needs trust for this individual. So they're getting an equal share of your estate, but that we're going to make sure that This trust, irrevocable trust, is properly drafted so that the beneficiary doesn't get kicked off of any of their public benefits. Yet there is some money set aside for them for their special needs that are not covered by the government, such as maybe a vacation, maybe bowling every week, maybe personal care, maybe they want to buy some jewelry, like whatever it is, they are allowed to use that money for their supplemental needs, is what the legal benchmark name is referred to as. So again, irrevocable trust, you have to be prepared to divest yourself of your assets that you're going to transfer into this trust in order for it to serve as an asset protection trust. Especially for Medicaid planning, you need to create and transfer the assets into this irrevocable trust 5 years in advance of the day you want to have the government pick up your nursing home bill, which, by the way, are running about $14,000 to $18,000 per month right now to privately pay for skilled nursing in a skilled nursing facility. The top features of a revocable trust: it avoids probate, it has flexible asset management during your lifetime. Irrevocable trust, it also avoids probate. Medicaid asset protection planning is what most people use it for, as well as supplemental needs trusts. You have two trusts to choose from when you're going to be doing your estate plan. So, what should you be thinking about to determine which trust you should get? Revocable is mainly reserved for estate planning. Irrevocable is normally reserved for asset protection. But the selection of which trust you are going to get for yourself is based on your individual needs, such as if you don't have a special needs person in your life, we're not going to be talking about an irrevocable trust. If you have a lot of long-term care insurance that you've already really prepared financially in the event you need to go into a nursing home. So maybe we're not going to be doing an irrevocable trust for you, and we're just going to be focused on revocable trust for probate avoidance and easy asset management. Is a trust right for you? It depends on what your goals are. You want to avoid probate? Then yes. You want to have privacy of your assets and your distributions at the time of your passing? Yes, a trust would be right for you. You want to start the 5-year Medicaid look back period? A trust would be right for you. If you want to do some tax planning, and that tax planning could be for married couples, we can set up a joint revocable tax planning trust with the estate taxes in Massachusetts raised to 2 million last year, so that if your estate is over the 2 million and you're a married couple, we can do a tax trust that is revocable, but that upon the first of you to pass, we'll get some tax planning in there to use up the first to die's $2 million exemption, so that when the second of you passes, you just want to make sure that your estate is under 2 million. And that's a very easy way to avoid paying Massachusetts estate taxes upon your passing. If you are a unmarried or single individual, that you really have to rely on other methodologies to reduce your Massachusetts estate tax threshold, so that when you pass away, your estate has less than $2 million in it. And we do that by funding irrevocable trusts or lifetime gifting and things of that nature. And then special needs person, if you have someone in your life that is, or if you are, a trust is absolutely right for you to be able to keep you on public benefits and still have you retain money that you can use for your supplemental needs. The summary of part 2. A will is a document that opens up probate. We use the probate court system. A revocable living trust is an entity to manage assets during your lifetime as well as after your life, and it avoids probate. An irrevocable trust is used for asset protection, special needs planning, and estate tax reduction.
If you would like help or have questions about this information, please give us a call at 781-229-0555 or visit our website at guthrolaw.com. We look forward to hearing from you.